I'm very well aware of the fact that I'm probably the only thing that is currently standing between you and your well-deserved reception afterwards. So I try to keep it short. As Klaus introduced me, I did a PhD thesis on that question essentially, and I want to go through these things with you really briefly. I'm actually very honored to be here, because I'm probably the only Zug born and raised speaker today. So I'm very glad that this event takes place here in Zug. So who is Wenger & Feely, the law firm I'm working for? We are a major business law firm in Switzerland with offices in Zurich and here in Zug. We have more than 40 years in business, deeply rooted in Switzerland. We have a very profound commercial and industry legal understanding. What we are doing here in Zug is mainly venture capital and private equity financings, and all sort of M&A transactions. We are a quite pragmatic team and deal-oriented team players. So when starting my research, I first had to start digging into what is actually impact investing, and I came across of approximately 50 definitions, and I finally decided to go with the definition of the World Economic Forum, because from my point of view, this was the most inclusive definition for all these reasons I listed in here. I started reading several reports on impact investing, and I came across about several questions on legal aspects. For example, from a corporate legal point of view, it was mentioned that there is no suitable corporate form, actually. And even today, I've been asked 3 times whether is it wise to have some sort of hybrid structure, or shall we go with one of the existing corporate forms, and how shall we structure this? Another question is the fiduciary duties of the board. That is somewhat linked to the fiduciary duties of asset managers. We have tax legal questions, whether there should be incentives for impact investing, some sort of similar to the tax incentives to donations. We have regulatory questions, as I mentioned, the fiduciary duties of asset managers. The legal questions do not only influence the investors, but also the social entrepreneurs. Implementing a double mission from the very beginning is probably very helpful. You could also set up protective measures for that double mission early on. That's much easier. You have no need for corporate cleanup before somebody comes in as an investor. And you're also some sort of protected against requests to focus on profit generation later on. I come to that later. So I just want to talk about implementing the double mission and also some fiduciary duties of board members. Implementing a double mission, we start with the definition of a corporation. I intentionally choose the corporation because that's probably the most evil corporate form considered from an impact investing or from a philanthropic point of view. So we have this definition, which already doesn't say much about whether it should focus on profit generation or not. But there is an interesting paragraph 3 saying that it could also be established for a non-commercial purpose. And that's the point where setting up protective measures early on or implementing such double mission is easier, because if you want to do that later on, you need a unanimous shareholders resolution. So can we now implement a double mission? We have seen that we can have, from the outset, we can have a commercial purpose, or we can set it up for a non-commercial purpose. But now implementing a double mission, is that permitted? From my point of view, since the law permits that, you can have a corporation with a non-commercial purpose. You could also set up one with a mixed purpose. I don't want to go into the details, but that's essentially my finding here. So if you want to set up a corporation with suitable for impact investing, you should definitely have it with a double mission in its corporate purpose, and then you could also implement protective measures such as increased voting thresholds in order to keep that purpose in your DNA, in the corporate DNA. For the duties of the board of directors, we go to this provision here in the Code of Obligations. That mainly requires the board of directors, A, to act carefully, and B, to act in the best interest of the company. So what is that, the best interest of the company? Lots has been written about that, and I don't want to go into the details. But from my point of view, the most determining factor of the duties of the board of directors is the corporate purpose. Everything else can be derived from the corporate purpose. The business plan, how many employees you need to get this business plan. So essentially, if you draft the corporate purpose appropriately, no other shareholders at the later point in time can come and claim that you should focus on profit generation. That's the reason why I suggest implementing these double mission statement very early on. Then we have another duty, a duty of long-term profit maximization. Also here, this duty rests on the perception of the corporation being a profit-generating entity. So that's some sort of logic consequence that the board needs to focus on that. We have different other provisions supporting this, and also what has been written in academic literature only focuses on financial profit generation. From my point of view, this requires a complete different understanding. If you go to the definition in the Duden, what Gewinn is, it doesn't necessarily focus on profit generation. Also, the distribution of profit to the company's members isn't actually part of the definition. So, therefore, I actually think we need to understand that differently. The pursuing profits should be understood as that what the shareholders actually want by stating that in the corporate purpose. So, long story short, a corporation may have a double mission purpose. This would fit on the one side the interests of the social entrepreneur, and also on the other side the interests of the impact investor. And also a properly worded double mission statement protects board members from being sued because they are accused to have their fiduciary duties violated. And we take a short glance at tax legal questions. There is the possibility to set up a corporation in the form of a charitable legal entity. The question is whether it's wise to do so. There are several benefits for that, but in order to do so, the company would have to fulfill several requirements. In reality, I mean, let's face it, if you have a young corporation, you don't have profit and taxes anyways for the first couple of years. So the benefit of not being taxed for your profit is probably useless in the first couple of years. Investments are unlikely to qualify as voluntary contributions and would not be tax deductible from an investor point of view. And as far as business entities are concerned, commercially justified expenditures could be deducted anyways, regardless of whether you are a charitable legal entity or not. And the problem is, if at one point in time you decide we want to drop that charitable legal entity status and we want to start distributing the profits to the shareholders, the tax authorities probably could go back and say, now you drop that status, we probably revoke your beneficial status from the very beginning. So and then you start paying taxes for all the past years. So from a practical point of view, there is very limited relevance for having a charitable legal entity, and you have much more problem of converting it then into an ordinary entity later on. So I already come to my summary. I think we're getting closer to the reception. My findings actually were none of the corporate forms provided by the Swiss Code of Obligations explicitly preclude impact investments. At the same time, there is actually no corporate form that is the perfect fit for impact investments. However, each corporate form can be, even a corporation, can be structured in a way to be suitable for all the interests of impact investors and also the social entrepreneur. And adopting that charitable legal entity structure is not recommended at all. It doesn't provide that many benefits, especially at the beginning of a corporate's lifetime. It doesn't outweigh the disadvantages later on. And especially with regard to all those reports that have been written about impact investments, I think the criticism that the legal framework in countries doesn't really support or even prevent impact investing is not true with regard to Switzerland. We have a legal framework that is probably following the traditional bifurcated view of the world and separating charitable and commercial entities. However, we can structure all commercial entities in a way that they are suitable for impact investors. So, this has been my really brief presentation about what I wrote 400 pages about. If you're interested, I'm happy to share that with you. And also, I'm happy to answer questions now or later on during the receptions. Thanks.